T-Mobile and Sprint announced their all-stock merger almost a year ago now, knowing it would be difficult to get approval to put together the third and fourth largest competitors in the market. But yesterday, things got even more difficult. Or did they? Here to explain where we are is Jennifer Rie, Bloomberg Intelligence Senior Analyst for Antitrust Litigation. To explain what happened yesterday, the FCC said we need more time.
Right. They stopped their clock in their review. It's a 180-day clock, and they were in about 122 days. What they said was, we got some new materials, a lot of new materials, just in late February and early March from the parties, the companies, and we need more time to review and more time for third parties to comment on these materials once we make them public. And this is pretty common, especially when new economic analyses and new evidence is submitted.
But give us a sense of how difficult it is to get this done. As I said, it's the third and fourth player. Typically, when the third and fourth player want to merge, people say we don't like that so much. That's
right. You know, and the thing is, it's a concentrated market, so it's made up of basically four players. It's not just that it's the third and fourth, but the top four make up about 99% of the market. So the concentration numbers are tough. And the problem is that what these agencies will look at, both the FCC and the Department of Justice, is the extent to which this concentrated market post-merger can be more open to sort of tacit coordination. And there could just be a price increase that happens because they can observe each other more easily in the market.
So that's on one side of it. This is a little different, though, than a straight-up antitrust analysis, because we have sort of a 5G issue kicking around.
Right.
When they announced the merger, we had the CEO of one of the companies who came out and said, you know what, this is really important for 5G. This is what he said.
5G. 5G is an imperative. The nation's leadership in 5G is at stake. We've fallen behind to China, and T-Mobile and Sprint together is the only company that can change that. So 5G is critical for the country. We're going to change that.
So, Jennifer, this raises in my mind, is this going to be a straight-up competition analysis, a traditional one, or will the concerns that President Trump and the administration has expressed about our being competitive with China, which brings up Huawei questions, and say, wait a second, we can't afford to be too scrupulous about competition right now?
Right, and I think that's the only chance this deal has, because if they didn't have this 5G argument, I don't think there really would be a valid argument to defend this deal. But the 5G argument, that they'll have these pro-competitive efficiencies in being able to compete in 5G and nationwide and have this robust 5G network and allow the U.S. to compete is the pro-competitive side. And what has to happen here are the agencies are going to look at that pro-competitive side and weigh it against the potential for harm in the market and see sort of which one wins out. And I think that these companies understood that this 5G importance to this administration and realized maybe this time, because it's the third time a deal like this has been tried, maybe this time we can do it because of the 5G issue.
Well, I was going to say, what kind of precedence is that? Like the harm versus the pro-competitive? Like when is the pro-competitive won out?
So that is a really good question, because really never. So, you know, the issue here is that the guidelines, and in theory, basically, these regulators are supposed to do that balancing test every time. Look at the harm and look at the pro-competitive side of the deal and balance them against each other. But to be honest, a court has never accepted a deal based on that argument. Now, it doesn't mean the agencies haven't cleared a deal based on that argument, because sometimes we don't know what the reason, their rationale for clearing a deal was. But a court has not.
And talk to Margaret Verster over in the EC right now with the Siemens-Alstom deal.
Right.
Because she says, I'm going to apply traditional competitional analysis. We're not going to let it go forward. And both France and Germany are so upset, the governments are, they said, we want to change the law, the competition law, to permit this sort of thing.
Yeah, exactly. And, you know, I think that also, if you look at this traditional application, if the DOJ applies a very traditional application here also, they might have trouble with this 5G argument, because the efficiencies that the DOJ is allowed to credit are those efficiencies that are merger specific. They can only be brought about by virtue of the deal. And both of these companies were talking about 5G networks before they were talking about a deal.
At the same time, if the Trump administration, if the president himself were to conclude this is really important for our country, is he going to be particularly reluctant right now to express that, given some of the reporting about the AT&T situation, where now there's reporting, we don't know if it's true or not, that the president really did try to intervene to stop the AT&T merger? Is there going to be particular stickiness there that says we don't want to get involved?
I think that many think there's some stickiness there, and particularly both the DOJ and FCC won't want to look like they've been too influenced by the White House. However, I'm not so sure they're going to be concerned about that. I think they're going to make their decision, and whether it aligns with the White House's position or not, you know, it's going to be based on their analyses.